Ladies and gentlemen, your webcast will now begin. I would like to turn the conference over to Ms. Cynthia Schoss.
Good afternoon, or good morning, depending on your time zone. Welcome to our webinar, and thank you for joining us. I'm Cynthia Schoss. I co-chair our Insurance Transactions and Products team here at Sutherland. I'm pleased to have with me today Michael Devlin, a principal at BCG Pension Risk Consultants, and two of my partners here at Sutherland, Carol Weiser from our ERISA practice in Washington, and Brian Barrett from our Insurance Transactions Capital Markets team, who joined us from Goldman Sachs, and Brian and I are in New York. Our focus today will be on pension de-risking transactions, the whys, whats, whens, and wherefores. Brian, would you please start the conversation by setting the stage for us?
Sure, thanks, Cynthia. We've seen 4 high-profile defined benefit pension buyouts over the last 3 years. GM, Verizon, Motorola, and Bristol-Myers Squibb have all executed jumbo deals. These companies transferred to an insurer the responsibility for making future annuity payments to certain participants in their defined benefit pensions. There have also been several other similar transactions of smaller size but of significant strategic importance for the companies involved. As for the insurers that take on the responsibility for making annuity payments, we have seen 1 new insurer enter the pension buyout space last year, and 2 more insurers are apparently now looking to get involved. Can you get us started, Carol, and tell us what de-risking means in the context of defined benefit pensions?
Thank you, Brian. Sure. De-risking can mean different things. It can include managing the risk through freezing of the plan or other plan design changes. It can also include changes to the investment strategy, often referred to as liability-driven investing or asset liability management through the investments. But most often, when people refer to de-risking, they really mean transferring the risk. In the case of paying lump sums, the risk is being transferred to the participants, usually terminated vested participants, but sometimes also including retirees who are in pay status. Today, our focus will primarily be on the purchase of annuities from an insurer and transferring the risk to the insurer in that way, and we usually do that with respect to retirees who are already in pay status.
I think the conventional wisdom, Carol, was that pension buyout activity would take off only after we exited from this low interest rate environment. What do you think might be driving plan sponsors to pull the trigger on deals now, this year?
Well, Brian, it's really all about liability and the increases in volatility that employers have on their balance sheet with respect to these liabilities. Even though interest rates are low, there have been good equity returns in the last few years, so that some plans at least have assets that are up in comparison, and therefore maybe somewhat more favorable time, even though, as you say, the interest rates remain low. Just last month, the Society of Actuaries released a new set of mortality tables, and these reflect an increase, and these are mortality tables specific to private defined benefit plans. The new tables reflect an increase in longevity, which equals an increase in liability. And depending on the demographics of a particular plan, that can mean an increase of anywhere from 3 to 8% is what we're hearing. We see some predictions or some reflections that it may be slightly outside of that range, but that's the most typical range, that 3 to 8% range. The tables, these new mortality tables, will probably be taken into account for many companies when they prepare their financial statements and reflect the liability for their defined benefit pension plans. on their financial statements, they will probably use those new mortality tables or at least have to consider the impact of those. The IRS is also likely to adopt those tables for purposes of setting the minimum funding standards for defined benefit plans and calculating lump sums. However, based on past practice, it is likely that it will take the IRS a few years before they do that. So the most immediate impact is likely on the financial statements.
And aside from these new mortality tables, are there other factors, Carol, that you think are incentives for plan sponsors to act now?
Yes, another factor is the significant increases in the Pension Benefit Guaranty Corporation premiums that we've seen in recent years, as illustrated on this slide. So all plans pay the per participant flat rate, which, as you'll see from 2013 at $42 a head, in 2016 will increase to $64 a head. In addition, plans that have unfunded vested benefits, that's the UVB, unfunded vested benefits, also pay a variable rate premium. And you'll see the increases there on the chart. The variable rate premium is capped at a per participant dollar amount, and those also are going up. And at this point, we really only know those increases through 2016, and then after that, they will be indexed. Mike will give us an illustration of the magnitude of these cost changes in just a couple of slides.
Mike, lump sums seem to be an attractive approach to eliminating pension liability. Do you think that plan sponsors should usually opt for a lump sum buyout of at least a subset of plan beneficiaries?
Yes, I think at the very least they should be exploring it. It may not be exciting in regards to how much actual pension liability they're able to remove from their balance sheet, but it can be exciting as to how much administrative and PBG fees they can eliminate for participants who no longer even work at the company. So it's always for your terminated but vested. And one of the advantages, it usually doesn't require a significant portion of your assets. There's usually minimum accounting impact. From a funding level standpoint, you're usually able to maintain or close to your current funding level after the term vested lump sum project. And we also remind plan sponsors that it doesn't have to be a situation where you're offering it to all your term vesteds. You could build a model to figure out which groups of term vested you are going to offer the lump sum. So, for example, you could start to look at everybody with a present value under $15,000 and then build it up to $25,000. You're really looking for when do you hit a point of resistance. But it's a common strategy, and we're seeing more companies implement this strategy.
And Carol, what are some of the things that companies should have front of mind if they're interested in pursuing a lump sum buyout?
Well, for a lump sum buyout, Brian, there are a number of issues under both ERISA, the Employee Retirement Income Security Act, and the Internal Revenue Code. The key issues under ERISA are going to be dealing with the disclosure of the option to participants and taking into consideration some of the cases that we've had that deal with various types of disclosure, needing to be very clear about what the participants are trading off in terms of no longer having PBGC protections, no longer having Title I of ERISA protections if they do take the lump sum, and what this might mean. There's also the question of what we refer to typically, the buzzword is serious consideration. So that's as Mike just said, typically these windows or these lump sums are offered to terminated vested participants who are not in pay status, but so often those individuals are eligible to go into pay status and elect at any time after, say, early retirement age. And you have an issue of when the window is opened and lump sums are permitted, do you have participants who have just recently commenced benefits and they say, oh, if I'd only known that you were going to offer this lump sum, I would have taken that, and they sue on the basis that you did not give them adequate information. There's also the question of the length of the window and when is the communication going to be done. Under the Internal Revenue Code, there are quite a number of technical issues. Probably the most significant from the employer standpoint or the company standpoint is that the lump sum does require both participant consent and, if the participant is married, spousal consent to waive the joint and survivor annuity and to commence the benefit early. So this is not something where the employer or the company is going to have a lot of control. In contrast, the employer would have more control over a pension buyout through a purchase of an annuity contract. And so that is something that an employer may favor, though, again, as Mike alluded to, a lot of it's going to depend on what's the employer really looking to accomplish, what's the group that they're targeting, what are the dollars, what are the PBGC premiums, because typically the lump sums will be offered to the terminated vested participants, and the buyout or the annuity contract will more often be issued to the retirees. And it will be very important to have fiduciary review and satisfy the Title I requirements with respect to the purchase of an annuity. Let's go on, just take a minute here and talk about where we are with the government in all of this. While we don't see any government action imminently, sort of not surprising, especially in Congress with what we know is happening, we do see some interest in both in Congress and in the government agencies on both the increased lump sum windows and the annuity buyouts. So there have been some congressional hearings on just the whole idea of de-risking, and we have seen Senators Wyden and Harkin, who are the Democratic leaders of the Senate Finance Committee and the Senate Health Committee, send a letter to the government agencies asking them to take a look at both types of de-risking and consider whether participants are being adequately informed and adequately protected with respect to the loss of the PBGC premiums, the PBGC insurance, and the protection of Title I. And we see the Department of Labor having hearings at their ERISA Advisory Council, the Pension Benefit Guarantee Corporation putting out a proposal to include in the 2015 premium filings that they may require a report on cash outs or annuity buyouts. And we're seeing right now that the PBGC is welcoming comments on that proposal, and the comments are coming in as to whether or not that would really be something that makes sense for the PBGC to gather that information. why don't we leave it at there and
Thanks, Carol.
maybe move on to Mike now.
Mike, we've heard Carol mention just a few minutes ago that mortality improvements are expected to result in higher gap liabilities for some plans. Do you think a plan's current gap liability reflects the real cost of meeting a defined benefit pension's commitments to its beneficiaries?
No, we feel that comparing the annuity cost or the cost to transfer the risk to an insurance carrier versus your gap is not really a true apple-to-apples comparison. In addition, we hear from plan sponsors that will say that it's just too costly in this low interest rate environment, and either their actuary or somebody's given them information that it's probably 20 to 30% higher than how you're accounting for it, and they look at that sometime as a premium. But the real answer is, even with in a low interest rate environment, that it's probably about closer to 8 to 10% based on actually the activity that we're seeing in the marketplace today. That's obviously a big difference. But the key thing to remember is that why it's not we don't think it's a good way to look at your cost to transact by comparing your gap number versus the cost to move it to the insurance carrier is that the liability does not sit on your balance sheet for free. Right? There's a holding cost that you will pay. So what we try to do is have companies go through an exercise of figuring out simply what is the present value of the costs associated with me holding this versus moving to the insurance carrier. So on the bottom, the yellow row is the annuity settlement cost. So that's roughly, say, $335 million to move all my retirees to an insurance carrier. And their accounting number, how they're accounting for it from a gap standpoint, is $300 million. And if you compare those two prices, someone would come to the simple conclusion of, do I really want to spend an extra $35 million above how I'm accounting for it to move to the insurance carrier? But what we want to do is you want to go through an exercise is figuring out, well, what are my holding costs? So the first one, starting from left to right, obviously the blue is my gap number. Then the present value of the administrative fees. So I have a provider and there's all these costs that are associated. That comes out to $3.87 million if I'm going to, once again, hold this until the last retiree passes on. The next one is the PBGC fixed premiums. So not your variable, just the fixed, and that comes out to $5.7 million. The next one is obviously there's underlying investment management fees that need to be considered, so your present value of that. Next is the credit defaults and downgrades for your fixed income, and the big one is that we've been spending a lot of time on is obviously the mortality improvements. The simple fact is your retirees are living longer. And in addition, you have the baby boomers retiring, so you have on the front end people entering the plan at a good clip, and then on the back end people are simply living longer. So after going through an exercise of this, we think that you have a fair comparison of exactly what your liability looks like and the cost to transact. And when companies go through this, it doesn't necessarily trigger a PRT, but it definitely gets them to start to understand how costly it is to manage this. They already realize that it's very difficult to manage this risk from a equity standpoint and interest rate, regulatory, and things of that nature. And then they look at this, and they really start to figure out when does it make sense to move it to an insurance carrier.
That's very interesting. Thanks, Mike, for going through that. I also understand that the cost of a group annuity can change pretty quickly depending upon rates and the interest on the insurance side, as well as other factors. How volatile can the pricing be? And if I'm a CFO or treasurer looking potentially at a group annuity solution, what can I do about it?
Sure. So if we take the last example of roughly $330 million of retiree liability, this graph is actually showing exactly what we view as how the insurance carriers were pricing that liability. So as you can see, the pricing has been one extreme to another. It's been below $300 million, and it's been as high as $330 million. So this is not to say that you've actually missed an opportunity, but it's more as an example of why companies need to start planning today and really put themselves in a position to transact under their terms and conditions. As we've already learned today, there is a lot to consider and things that need to be done well in advance. So we always are telling plan sponsors that even if you think you're 3 years away from either terminating or doing something, that it's better to start today because there's a lot of things to do with data cleanup. You have to look at it from a fiduciary standpoint, a call on cash, the accounting impact. And as you can see, that there is ways to time the marketplace. The other mistake that we see companies make is that they will go through an exercise of what we call price discovery. So you go out to the marketplace, you engage somebody to represent you, and goes out to the marketplace and finds out how much is it going to cost for me to move my retiree liability to ABC Insurance Company. And they make a decision, yes or no, where we think that's not the best way to go about it because, as you can see, that pricing was changing every day based on rates, based on the insurance carrier's appetite. So we think you really don't want to just make a yes or no decision. You want to make a no, this price doesn't make sense. But if we go back to the previous slide and talk about the holding cost, you start to formulate an idea as to when it makes sense to move this to an insurance carrier. And then you simply have someone that once again monitors that pricing pretty much on a weekly basis so that when the stars are aligned or the rates and the insurance carrier appetite and all of a sudden that price that you're looking for is available, you're in a position to transact. But as you're learning today, there's a lot of things that need to be done in advance. But price discovery is key. And on top of that, the second key thing is to monitor it on an ongoing basis because you can transact under your terms and conditions.
Thanks for that, Mike. Now suppose a treasurer CFO has made a decision that, yeah, we want to execute a pension buyout. Cynthia, can you give us a sense of what executing such a buyout entails?
Sure, Brian, thanks. When a company decides to move from a game plan, such as Mike has described, to the actual game, the strategic alternatives, benefits, and risks will already have been carefully analyzed and considered, and the company's focus will turn to execution. And once they've started, to minimizing execution risk. The good news is that pioneers have paved the way, and this is an increasingly well-traveled path, but not only for the jumbo transactions. So let's walk through the elements of one of these transactions. We can start with the parties and the paperwork. The company that's the plan sponsor, together with the fiduciary for the plan fiduciary, will manage the process by which the annuity provider is selected, and the annuity and the definitive purchase agreement, or DPA, will be negotiated. The annuity is a group annuity contract, and the plan participants covered by the transaction will receive certificates. The definitive purchase agreement is the agreement to purchase the annuity, and it covers the terms that are external to the annuity. For example, reps and warranties, covenants and conditions, whether the consideration will be cash or in-kind assets or some combination, and the terms that go with that determination. Obviously, the company is unlikely to have done this before and won't be doing it in a vacuum. Typically, there will be a consultant and or an investment bank, as well as actuaries and lawyers advising the company on process, the options, the issues, and cost. And the lawyers will probably include ERISA, insurance, and M&A lawyers for the DPA, which is a purchase agreement, as well as tax counsel. They will also advise on mitigating liability. There's been some litigation on some of these transactions, but to date it has been unsuccessful, largely dismissed on motions. The insurer that is providing the annuity might also have outside counsel. The insurer is responsible for having obtained or obtaining any required regulatory approvals for the form of the annuity, for the certificates, and for the plan of operations for the separate account, if applicable. And in a buyout transaction, it's the insurer annuity provider that will assume the payment reporting responsibilities previously performed by the plan fiduciary. To satisfy ERISA requirements, and depending on the size and complexity of the transaction, there might be an independent fiduciary among the parties. And that independent fiduciary will also be involved in the negotiations and might itself have outside counsel and actuarial advisors.
And is there a typical process that's been followed in the deals on which you've been involved, Cynthia?
Yes. We have an illustration of a buyout transaction in the slides, and this is intended to give you an idea at a very high level of the phases or steps and the sequencing. The timing could vary, possibly by quite a bit, so we haven't put timeline elements on this chart. Prior to phase one would be the analysis and game plan that Mike described. Then, when the board is on board and the company plan fiduciary is ready to pull the trigger, the company would shift into execution mode, as we just discussed. In the first phase, this would involve hiring or rehiring advisors, structuring the transaction, determining the participants, and commencing the process of choosing the annuity provider. This could involve several rounds of RFPs and responses. Phase two would begin upon the selection of an annuity provider, although some negotiations obviously take place during the selection process too, particularly if you're going through the RFP and response process. In this phase, the parties, which, as I said, could include an independent fiduciary and its advisors, negotiate and execute on a definitive purchase agreement and a group annuity contract. The details revolve around the data about annuitants and the effect on the premium, asset valuations, if you're talking about anything other than an all-cash premium, true-ups, adjustments, conditions, things like that. If not already obtained, or if there's a need to refresh them, this is when insurance regulatory approvals would be obtained for the annuity contract, if required, possibly for the plan of operations for a separate account, and for the certificates. This would also be the phase when communications are sent by the company to the annuitants. And then phase three would involve transitioning of the plan administration and post-closing true-ups and other adjustments. I think that concludes our webinar session on this topic. We hope you've found it interesting. If you have follow-up questions, or if we've just whetted your appetite with this high-level overview and you want to hear more, or if you'd like a copy of the PowerPoint, please call or email any of us. Our contact information is on the screen. And again, thank you for taking the time out of your busy day to spend some of it with us talking about these topics.